One of the things I'm frequently asked by non-lawyers is, what's the difference between federal and state court? In just a moment, I'll explain that. One of the things that we have in this country is a principle called federalism. And federalism generally provides that the states are sovereign and the nation as a whole is sovereign. And that as a result, we have two sort of overlapping forms of government: the state government and the federal government. When the Constitution was set up, it was set up with a number of federal courts. Now, the only federal court that is mentioned in the Constitution is the Supreme Court. And then Congress was empowered to create other lesser or inferior courts as it saw fit. And as a result, it has created the federal district courts. There is a federal district court in every state and territory in the country. There's a federal district court, for example, in St. Thomas in the Virgin Islands. This federal district court is charged with two things. It can handle civil cases that arise under federal law, under either what's called diversity jurisdiction, where the citizen of one state sues the citizen of another state, or federal question jurisdiction, where someone sues an individual or entity under federal law. And then it also has the jurisdiction over federal criminal offenses. That's what federal courts do. They hear cases involving federal law and diverse citizenship, meaning, again, that someone from Nebraska sues someone from Missouri, for example. State courts are the courts in every state, and they hear cases that originate within the borders of their state, usually, although sometimes that's not the case. They hear state law cases. Where cases are predicated on state law, then usually it is a state court that hears that case. So, for example, if someone is injured in an automobile accident, for example, they're rear-ended, and they have a back injury as a result, and they sue to recover damages. In most cases, that's a case that is tried in state court. Now, there is an exception. I mentioned before that people who are of diverse citizenship can sue in federal court. So if the person who hit another person in Missouri happened to be from Kansas, then that lawsuit could be brought in Missouri in state court, or it could be brought in the federal district court of Missouri, as long as the amount in question was greater than $75,000. A lawsuit between citizens of different states has to meet a jurisdictional threshold. It has to claim damages in excess of $75,000. Now, there's all kinds of exceptions and caveats to that lawyers learn about in civil procedure course that aren't really relevant here. That's the general outline of how you get into state and federal court. But there is one other way, and that is through a process called removal. Let's suppose that the individual in Missouri who is driving a truck for Acme Enterprises rear ends the person from Kansas. And the person from Kansas sues that individual in state court in Boone County, Missouri, which is on I-70. The defendant, if the damages claimed are in excess of $75,000, can remove it to the federal district court, which sits in Jefferson City. And that case would then be heard in Jefferson City, in federal court, and that's where the case would be tried, unless there was some reason to remand that case back to the state court. And there are a number of reasons why a court might do that. That's probably beyond the scope of this little presentation here. But basically, state courts hear state cases. They can involve citizens of the same state, citizens of different states, and what really matters is that the basis for the claim is a state law, although in some cases, some people do sue citing federal law. Of course, if you cite federal law, you can be removed to the district court for federal question jurisdiction too. So that's how a lot of lawsuits wind up in federal court, is because people plead for federal causes of action. All that said, the differences are not as significant as they might be thought. You still have the same burden of proof in a civil case as you would in a federal court that you would in state court. You still have the same number of jurors, usually 12, in state or federal court, although some cases in some federal courts are tried with only 6 jurors. The only difference may be in the rules of procedure in terms of how the cases are handled. For example, in Missouri, a verdict for a civil case doesn't have to be unanimous. You can have 9 of the 12 jurors reach a verdict, and even though 3 jurors don't like the outcome, they're powerless to stop it. You get a verdict with only 9 jurors out of the 12. But in federal court, you have to have a unanimous verdict, whether that's federal civil or federal criminal. That's an important distinction, and one that makes a difference. In addition, the federal rules of civil procedure and the federal rules of evidence apply in federal court, whereas the state rules apply in state court. And those are not too wildly divergent. They are generally fairly harmonious, but there are a lot of hoops that lawyers have to jump through, so most of the time plaintiffs' lawyers don't like to be in federal court. Speaking from personal experience, I don't really like being in federal court because I often find it to be skewed in favor of the defense. But that's just the way the ball bounces, and you have to be able to win cases no matter where the case is tried. So I hope you found this presentation interesting and helpful on the subject of federal versus state court. If you do, I'd appreciate it if you'd click the like button and maybe subscribe to my channel. It would help me out a great deal if you would do that. And if you click the notification bell, you'll be notified every time I release another video. Thank you for watching, and have a terrific day.